Welcome, everybody. I'm Jennifer Morris, the Executive Director of the North Valley Property Owners Association. I hope you'll bear with me. This is the first time I've done the Landlord 101 with a PowerPoint presentation where I'm sharing my screen. I wanted to do this type of recording because I know everybody has a really busy schedule and you're not always able to come into the workshops that we're starting to do in person, nor join us online. And so I wanted to be able to use this as a way to reach our members in a time-sensitive manner. So to begin Landlord 101 workshop, I like to start this workshop with talking about setting your rental criteria. When I talk about this, I talk about the Uniform Rental Policy Statement. That's Form 151 in our forms library. It's to use as a cover letter to any of your applications that you would hand out to your prospects. I like it because it allows for your policies on how prospective applicants will be meeting your criteria, and it puts those policies in writing so that if there's a time that you get engaged in conversation with somebody, this is an opportunity for you to make sure you have a consistent way of saying to every applicant what your criteria is and how they'll meet that. This form goes over the max number of occupants. There is not currently a law that states total number of people that would be allowed to live in a home. However, HUD does have a recommendation that they usually say it's reasonable for 2 people per bedroom plus 1 for the living room. So for example, if you had a 3-bedroom home that you're renting, it would be reasonable that the max number of occupants that you would allow to live in that home would be up to 7 people. So 2 people per bedroom plus 1 for the living room. Now, everybody has different size of homes, and so you may decide that that is too many people, 7 people to live in your home. So it doesn't matter to you what their relationship is, what their age is. None of that matters. The point is that you just state ahead of time before putting your property on the market what the max number of occupant limit is going to be for your property, and then stay consistent to that. And you do need to be reasonable. If you had a 3-bedroom home and you only wanted 1 person to live there, that's probably not going to be a reasonable amount of people to allow for that accommodation. So set your policy and be consistent. Knowing the security deposit laws, California says that we're allowed to charge up to 2 times 1 month's rent for a security deposit. So any money collected other than the first month's rent would be considered a security deposit. It doesn't matter what label you put on that deposit. If you say you're going to take an additional deposit for a pet, or if you're going to take another deposit for some other kind of fee. I can't think of one off the top of my head, but if you're going to be doing that, you need to make sure that all of the amounts will not exceed more than 2 times 1 month's rent. Also, in 2019, there was some legislation that passed that if you are renting to somebody that's active military, I believe the max that you can charge on their security deposit is 1 month's rent. So be sensitive to that. If you have any questions about what you're allowed to charge for security deposits, give our office a call. And I put down here understanding price gouging laws when considering rental rates. Of course, the association has no authority to give you any indication to what you should be renting your property for. That's your decision. I only put that in here because we do have some recent laws, I should say, from California Penal Code 396. The governor signed in November of 2018. He signed into legislation an executive order saying after the Camp Fire that there was declaring a declaration of emergency. Once the declaration of emergency has been declared for the area in which your rental is located, you have to wait. That means that you won't be able to increase any rents by more than 10% of what they were previously rented the day before the declaration of the emergency was set in place. So for our area, Butte County has had a declaration of emergency in place since November 7th of 2018. It is set to expire on December 31st of 2020. I don't know yet because today is November 10th of 2020. So I don't know yet if that's going to be expired at the state level or at the local level, but there is a declaration of emergency. And so through that time frame, that means that you can't go over 10% through a full declaration of emergency. That doesn't mean 10% annually, which most of our membership do not do increases of 10%, but you aren't able to do a 10% increase annually. It's through the full duration of that declaration of emergency. So make sure you're aware of that. The next topic I wanted to talk to you about is animals. I think it's a good idea. We ask it on the application that NVPOA offers. Will there be any animals living in the home? And the reason why we say animals is because that could also include anybody who has a medical device that's considered a companion animal, a service animal, an emotional support animal, a therapy animal, whatever you would like to label it. That is not actually a pet, and so it should be treated differently. Companion animals would not be charged any type of an additional deposit, nor would they be able to be charged pet rent because it's not a pet. This is a medical device. And so the step in dealing with that process is to give them an application just like you would anybody else, and also give them a form that's called a request for reasonable accommodation. This will allow for you to see clearly exactly what their request is, that they're asking for a modification of the terms of your agreement. A pet, you would be able to charge an additional pet deposit as long as you're not exceeding California's limitations of 2 times 1 month's rent for a security deposit. And some people choose to charge additional rent for pets as long as you're not going over the max 10% through the duration of any declarations of emergency. And on that note, I did also forget to mention the governor currently had put in a declaration of emergency for the COVID-19 in March of 2020. And then also due to the August fires that we had, I believe Butte County and Shasta County also have a declaration of emergency on those dates. So check with us or check with your local district attorney's office, and they can let you know if there's any current declarations of emergency that would impact what you're considering for rental rates. The next thing I like to talk about is showing the upcoming vacancy. Single family home showing and multifamily home showings are a little bit different, as you can imagine. Typically on a multifamily property, there's a good chance that you may have something that's vacant that you have the ability to show to a prospective applicant that wouldn't interfere with the current resident, nor would it interfere with having to give a 24-hour notice to enter the property to view that. Single family, and also it's usually the same layout that you would be renting to applicants. And so you usually can show an unoccupied property at a multifamily property that is usually probably, 16 units or more. It's probably pretty common that you'd have some kind of turnover that you might be able to show to somebody. On a single family home, obviously the layout is going to be different every time. And so it's always a good idea to have pictures or videos on hand that you can use to market to any prospective applicants when you know you have an upcoming vacancy. That way you can make sure people are interested in viewing it without having to interfere with the current resident's schedule very much. You also, again, like I said, need to provide the current resident with 24-hour notice before showing it to any prospective applicants. Now comes the interesting challenge that everybody had to kind of adapt to with COVID-19. And would you choose to show the property during this type of pandemic, or are there creative ways that we can use to be able to show it? Some people had asked their residents to be willing to do a video that they might be able to share to any prospective applicants. Sometimes owners would give 24-hour notice, and then they would take pictures, or they would do a live video with the prospective applicant so that they could reduce the exposure to their current resident. In my honest opinion, I think it's better to show an unoccupied single family home, but I know that not everybody has the ability to do that, because obviously the goal in your investment property is to have it rented and receiving rent as often as you can. So having a vacancy for too long could be a financial impact that you're not able to do, and that's fine. But you do need to be willing to try to make accommodations and think outside of the box during the COVID-19 pandemic. Maintenance and cleanliness is always really important. We're in a market, and we have been for some time, where we have a very low vacancy. But when we have a higher vacancy, it's really important to make sure that your properties are definitely in a showable condition, that all the maintenance is done and it's maintenance free, that it's clean, and that it smells good. Obviously, when we have a lower vacancy, it's a little bit difficult to make sure that it's a little more difficult to make sure that you can accommodate that, because you may be doing turnover, you may be trying to get it ready to rent to somebody else, and you're under the obligation to then try to get it rented quicker, and then it's more difficult to do it, of course, when everything's done and in the move-in ready condition. So everybody's situation is a little bit different. I encourage members to do a little pre-screening before they I encourage people to do pre-screening before they do start to show the property. If you can kind of run through some of your uniform rental policy statement policies, such as you're going to require X amount of gross income per month, you're going to check credit, you're going to check rental history, the max number of occupants is X. Will there be any animals there? Kind of running through some of that information is a good idea to do over the phone, so that way you can see if these people would meet your qualifications. And of course, it's always the best idea to give somebody an application who is interested, to avoid any type of fair housing lawsuits. I suggest using videos and pictures. It's a good idea to do this, one, for your marketing purposes, but two, to also show the cleanliness and maintenance of the home prior to a new resident taking occupancy. The burden of proof is on the owner to be able to show what that condition was like when they moved in. So it's really important to take videos and pictures, as well as a written move in and move out walkthrough sheet. Also, doing open houses would allow for you to give 24-hour notice to your current resident, be there with a couple people that maybe work with you, so that you can ensure that everything is being watched, and that the current residents' items are going to be protected to the best of your ability, that people don't come in and try to steal items at open houses. But you also would be interfering less with your current resident schedule if you have the ability to try to stack all of your showings to prospective applicants that are interested into the property. What to look for when qualifying applicants? I always like to ask 3 questions. Can they pay their rent on time? Will they take care of the property? And will they be a good neighbor? When you're thinking of those 3 questions, then you kind of come down to, what are you going to require for the proof of income? I would say in our area, it's fairly common that it's going to be, industry standard that people charge 3 times 1 month's rent for gross income. They also check current and previous rental references, and that's really important because, if you only call the current resident, the rental reference for that person, they may, have a pretty good incentive to try to get them out of the property. And so I suggest that you go ahead and call any of the previous rental references, so that way you have the ability to make sure that you're getting a good rental reference on your prospective applicant. Credit screening reports. The North Valley Property Owners Association does have a tab on our website. If you don't have a way of getting these already through a software system that you might use, some of the larger management companies use systems that already have a built-in credit screening function. And so if you do not have that type of capability with that large management company system, then NVPOA has at nvpoa.org a tab called Resources. If you click on that and then you go to credit screening reports, there will be a couple options. You can either do a direct pull, or you can for credit reports, or you can have an account where you sign up for free, and then you enter just a little bit of information about yourself as the owner, create the account, and then once you have a prospective applicant's application in hand, then you would email them an invitation to go to the link associated to your account through Apply Connect, and then they would go ahead and enter their personal consumer information, pay $28.50, and then a full credit report would come back to you in an email through that account. It would include their credit score, the credit report, the national criminal report, the national sex offender report, and the national eviction report. California has kind of gone down a path of restricting some of the things that we do see on some of those reports. that they are prohibiting, such as being illegal for you to deny somebody housing based on an arrest record. That information you won't see in those reports, and so it's filtered a little bit by the IP address. But it's important that you do spend your due diligence on trying to qualify your prospective applicants thoroughly, so that you can avoid any issues down the road, 90% of the time, I would say, by getting their current proof of income, getting current pay stubs, bank statements, tax returns, whatever they can provide to you that is current and up to date, that shows that they do in fact have that type of income, is what you need to get from them. Checking the rental references. If you're able, ask open-ended questions or send a written document attempting to get the questions answered. I usually like to ask questions like, what were the dates that the applicant lived there? Owners usually know or have an idea about when the applicants lived there. I also like to ask the question, what amount did they pay in rent per month? That's a good idea, because then if you're, the rental that you have is considerable amount different than what they had previously been paying, you want to really look into their finances on their credit report to make sure that it looks like they can be able to pay that rent. And so, asking the question of what they paid for rent. Again, somebody who's the acting landlord, the friend that might be filling in to answer the questions and help their friend get the home, they may not know that information. But typically, I would say owners usually know what amount of money they're receiving in rent and who their renters are. So asking open-ended questions. And I always like the questions, what was the question? It's, would you rent to them again? Now, I know some people have come up with a little bit of a generic answer to this, and some people will say if they meet the qualifications. But I still like to ask that question, because if you do feel like a long pause, then there's an opportunity for you to kind of maybe get some more information out of the owner, or just pay attention to that and make sure that you're really peeling back the layers of the onion and doing your due diligence and making sure that you see the full picture. Sometimes people ask me, well, what's a good credit score? What should we be looking at? Well, I personally don't really like the credit scores. I don't think that tells you the full picture. But if you do start to get something below 600, there's a good chance that there's some current issues that have happened that have resulted in their credit being that low. Typically, owners would like to see something above 600, but there's always situations with each set of applications that may make the difference of why you decided to make an exception. Please keep in mind, though, that if you do make exceptions, that does put you at risk for fair housing issues, for somebody saying that they were wrongfully denied housing when you made the exception to somebody else. So consider that. And if you have questions one-on-one about that, please give Katie or I a call. We'll be happy to go over that. Other important tips for screening. Everybody that's 18 years or older needs to fill out their own application fully, even if the one applicant is financially responsible for the rent payment for everyone. You still want to get an idea of who everybody is that's living there, and asking those 3 questions. Can they pay rent on time? Will they be a good neighbor? And will they take care of the property? In 2019, there was legislation that passed for 2020 saying that it was prohibited of owners or management companies to put in their ads that they do not accept Section 8 housing vouchers, or to even say it on a phone call, because we on occasion would get prospective applicants saying, do you accept housing vouchers? We're no longer able to say that we do not. Kind of an answer that you may give to somebody is that we give everybody an application that will meet our, sorry, excuse me. An answer to that would be that you'll give everybody an application, and then you will qualify everybody the same, and whoever meets those qualifications will be the ones that you'll be renting to. The reason why that law came about is they consider it to be discrimination of source of income. And so what you would do is you would take the voucher amount, if they have one, and you would apply it to one amount in rent that they need to pay as part of their proof of income. So that is part of that law that changed. If you have questions on that, that's SB 329, I believe. And best practice suggests that once you approve an applicant, then you execute a joint and several rental agreement. Everybody has different reasons for why they choose to do individual rental agreements, but I think that it's less paperwork and put some ownership on the residents to get along with each other, because they usually found each other to move in, live with each other. And so if they start getting into roommate disputes, joint and several is typically a better document to have than individual room leases, but everybody has different reasons for why they choose to go one way or the other. If you do choose to go on a joint and several rental agreement where everybody's jointly responsible for the rent, then everybody also needs to sign that rental agreement. In guarantors, they would actually have a little bit different of a process than a normal application. That's Form 114 in the forms library. And you would complete the top portion, fill in the blank areas, and it would be for the total amount of rent, even if they were only co-signing for their son or daughter typically. It wouldn't be their portion, it would be the total amount of rent per month. And then the guarantor would fill out information on the bottom. I stuttered over the co-signer word because co-signer typically means that they actually are somebody that then has the ability to live in the home. Typically, our guarantors are somebody who is only taking on the financial responsibility of any unpaid rent or damages to the property, not that they have any intentions of living at the property. So it's a guarantor. So Form 114, you can use that in addition to the applications that the current residents would fill out. And then that would be all part of your qualifying process, making sure that your guarantors do make a certain amount of provable gross income. Usually it's 6 times, because if it's usually 3 times, a guarantor would need to be able to show double that to be able to cover their own bills as well as that of the resident that they're guaranteeing for. And then also, when you do move somebody in, I suggest that in addition to the full month's rent, that you also take the security deposit. And I like to have that in a cashier's check or a money order. Sometimes people will do a prorated amount at move-in, and I like to have the full month's rent at move-in, and then the next month is when they'd have to pay the prorated amount. The reason why I like to do it that way is just because over the years when I was a resident manager, there were times that it was easier for people to come up with a lower amount of money, whereas if they have the first month's rent and the security deposit to come up with, which was a lot of money, they weren't then struggling before or after they moved in. They would kind of be struggling before they moved in, and so that you would see that they truly can afford to pay the rent, and you'll continue on a better path with your residents. The move-in paperwork, I do think that everybody needs to sign the paperwork. That makes it a much better situation where it's very obvious and it's in writing who the responsible parties are. I suggest that before you give the residents keys, that they can show you proof that they have already turned utilities on in their name, so that way they don't live there for a few months with PG&E being in your name. And then, like I said, take a cashier's check or money order, and if you're going to take a personal check, just make sure that it clears the bank before you do allow them the keys. I never let a resident move their belongings into the property before you have exchanged money with them and have paperwork signed. Sometimes people get a little ahead of themselves, want to help out the residents because they obviously don't want to pay double rent in too many spots, and I get that, but they'll allow them to move stuff into the garage, and then pretty soon they move stuff in the house, and you're not ready with the property being, completely ready for a move-in. It just doesn't make the process very clear. So stick to your guns and make sure that you have already executed rental agreements and already received money for rent and the security deposit. Please don't ever not take a security deposit or take payments on it, because there's a high chance that you're not going to get the payments back on that security deposit. Make sure you take pictures and videos of the property, again, to document the condition that was given to them. Again, the burden of proof is on you to be able to prove that. So don't just give them the move in and move out walkthrough sheet and ask them to complete it. Pre-fill it out if you'd like to save you time. And then, of course, tell them that they can have a week to add anything to it, and you can give them a copy of it, but don't give them the full form. Once you have moved a resident in, It's important too that you respond quickly and in a timely manner to any maintenance needs that the residents do have. Sometimes people have higher standards, and so it's important to them that maybe a closet doorknob fell off, and maybe for you're working all this time, and obviously you have another job usually than just the rental, and so it's a little harder to get over there with your schedule. So kind of consider this. Is it a I think is it a blood, a flood, or there's another one. I can't remember it off the top of my head, but is it a health or safety emergency is my point. Making sure that if it is a health and safety issue, that you do respond to it as quickly as possible. Make sure that you don't imply that you're going to repair some things. If you advertise that it has a new washer, a new dryer, a new dishwasher, all of these amenities, but then you have no intention of repairing those items or replacing them should they break, your advertisement may be implying that you will take on the warranty of making sure that these amenities are in working, and you would be replacing them because it's considered part of the rent. So just be careful in the wording of your advertisement. Know what the California habitability standards are. Make sure you get requests in writing. If you're not able to get it in writing from them, make sure you document it yourself, the date and time that you spoke to and who you spoke to and what the conversation was, and then put a note in there to follow up about what was done to complete the work order. We already talked about making sure you're aware that before you enter a resident's home, you need to provide them with 24 hours written notice, and that includes the backyard or any fenced areas. If your front yard's fenced and you need to get to the front door to post a notice, you can enter the front yard area, but don't go into anybody's basements or attics or backyards without first posting a 24-hour notice. Annual inspections are important. Usually you can post a 24-hour notice or do something that's a week out saying, I'm going to be entering the property on this date from these times, to be able to look for preventative maintenance. And that includes things like leaks under the sinks, dry rot in the window seals, just making sure that the air conditioning filters and heater filters are changed on a regular basis, and that the smoke detectors and carbon monoxide detectors have batteries and are up and working. Roommate disputes, that's probably a whole nother webinar, and we can probably do that, but I think it's a good idea for you to make sure that you try to, if they found each other to live with, usually those disputes are disputes amongst themselves. And they do try to pull you in. I would try to pull yourself back out and not participate in those types of discussions. If they were qualified to live there together and it's not working out for the living arrangements, then they can simply give you a 30 days notice if they're month to month, or they can provide you with notice that they need to vacate and then attempt to find somebody that is qualified to move in with the roommates. But usually those disputes are their disputes. If a resident does something where they breach the rental agreement, in that situation, you would give them a 3-day to perform a condition covenant or quit, telling them, hey, you breached the contract, you have an opportunity to correct it or cure it, and you have 3 business days to do so. If it does not mean that they can move out, it does not mean that they don't have to pay rent. You'll have to just play that situation specific to what's going on with your property. Give us a call if you have a situation, because it's obviously a case-by-case basis, but you do have the ability to serve a professional notice that would let them know that they've breached the contract. The same for non-payment of rent. We have a little bit going on right now for COVID-19 stuff, but in that situation, sorry. Okay, so the resident, so I was beginning to speak about AB 3088 laws, which is COVID-19 related. It's a California COVID-19 Tenant Protection Act of 2020. It was passed into legislation in September of 2020, and it goes through January 31st of 2021. And basically what this is it was just a way to protect tenants from being evicted for being impacted by COVID-19 and non-payment of rent. We do still have the ability to serve 3-day notices to perform or a 3-day to quit if the violation is severe, where they aren't able to correct the situation because they breached the contract, and that's really, really severe. That's usually something related to breaking law and that sort of thing. So very severe for a 3-day just to quit. Um, for anybody that does need to serve a notice of termination of tenancy, if they're month to month and they have lived there for less than a year, it would be a 30-day notice. If it has more than a year, it'd be a 60-day notice. The difference under AB 3088 is that we now have to list one of the reasons, we have to list a reason, and one of the reasons for giving the termination notice that the owner is the one giving it would have to be one of the no fault reasons under AB 1482 legislation. That in itself is kind of complicated. And so, of course, call our office. We can give you a little bit more information on those legislation pieces and how they might be shaping what notice you're able to give, or if you're able to ask a resident to vacate the property. If you are able to give the resident a notice of termination, or they've given you notice that they're planning to vacate or not renew their lease, be sure to give them Form 165, that's in regards to their pre-inspection walkthrough form, saying that within the last 2 weeks of their tenancy. It's an opportunity for them to correct any of the situation that they otherwise would have been charged against their deposit, if they can. There are times where residents maybe had holes in the walls and they're not a professional drywaller or painter. And so you would just simply let them know that that's a charge, and a professional company would be fixing that at the end of their tenancy, and it would be charged against their deposit. You do have 21 days to account for the security deposit after a resident has returned possession to you. Now, this is really important because there are times that residents have to leave the area for a job and they're not able to give you, they'll give you the full notice, but they aren't able to live in the home through that full notice. And so let's say somebody gave you notice, they're on month to month, and they gave you notice that they're going to be moving out on the 1st of January. Well, that notice, because they're month to month, should have been 30 days. So around the 31st of January would be when their responsibility date would expire, and then they would vacate. If they need to leave on the 15th of January, then the 21-day period of accounting for their security deposit would start the day they give you possession on the 15th of January, not the 31st or so of January. So make sure you follow that carefully. And I believe that it does include holidays and weekends. It's not just business days. So make sure, this is probably the biggest issue people have lawsuits over, is the accounting of their security deposit. So be sure that you do account for that by giving copies of invoices and receipts. If you have to estimate work because there's a lot of turnover that needs to be done that you're not able to complete within 21 days, do an estimate that's high and just make sure you have it postmarked within 21 days. Once you've completed the work that you estimated, or maybe it was rent that was still owed, and then you got the home re-rented, do a new accounting of the security deposit statement and send that out to them within 14 days of either the rent being paid by a new resident, or the items that you had to have fixed in the home being repaired. Make sure that you take pictures and video. Again, the documentation and the proof of what was damaged and what was clean is going to fall onto you as the owner. So make sure you have a before and after if possible to be able to show those conditions. Make sure that you allow time between one resident moving in and another one moving out. We have sometimes some people, especially this happens during usually the student turnover timeframe, where we have some residents vacating on June 30th and the intention of residents moving in on July 1st. That's not enough time to be able to complete properly a turnover process. You're going to stress yourself out. You'll stress out the residents moving out and the residents moving in. And typically they have people that are there attempting to help them move into the property too. So I suggest at least 5 to 7 days in between turnover. If you can do it quicker, that's great. Just make sure that you are allowing for time to make sure things are properly painted, enough that it would maybe be a complete paint, but it's touched up to the point that it's now considered a complete paint. Sometimes after 3 years, you usually do a complete paint, and that's not charged to the tenants. And then allowing for after you do painting, doing any maintenance or repairs, then doing any cleaning that needs to be done, then doing any carpet cleaning and pest control work that you might want to do to the home prior to moving in your next set of tenants, so that hopefully you're giving a new clean slate, a new clean moved in home to the next resident, that you have a new slate to start on, so that you don't have to check that things were not clean when they moved in, because the security deposit can only be used to return the home to the same condition it was at the time of move-in. And that statement right there is so subjective to either the owner's opinion or to the resident's opinion. We hear often the resident will say, it's cleaner now than it was when I moved in. I think we all see things a little bit different in our vision. Maybe they can't see the dust bunnies. I don't know. And maybe they lived there for the full year and they didn't clean anything, so to them it looked really clean. Everybody has their own opinion of what that looks like, but the important thing is that you take your pictures before they move in, and you take your pictures when they move out, so that you can be able to show those conditions. If you are not given their forwarding address, then the last known address will work to send the security deposit itemization to. You would just simply mail it out with their names on it to the rental address that they were previously renting at. Either it will be picked up with a forward in the mail, or it will come back to you and then you'll leave it unopened. If they do in fact owe you money above and beyond the security deposit, if you haven't heard anything within, say, 30 days after mailing that out, then perhaps you can go to a collection agency or go into the court and try to get a judgment against the residents for that unpaid amount that you need to try to recoup. I don't know if this is a California law, but I would say that it is good business practice to always change the locks in between every resident, because we don't know who the residents have given keys to. And I think the liability is tremendous if something were to happen to a resident where they can prove that somebody had a key to the home and they were assaulted or they had items stolen from their home. So it's highly suggested that every time you have a resident move in, that the locks have been changed for them. And then when they move out, the new residents get locks changed for them too. And so normally this is the part where I would ask any questions of anybody. Of course, there usually were questions that were asked along the way, but I hope that you find this is an easy way to be able to do the Landlord 101 workshop virtually. And please feel free to reach out to Katie or myself. Our office phone number is 345-1321, or you can reach Jennifer on her cell phone. That's me, at 530-228-0979. And of course, we have our emails. Katie is assistant_nvpoa@gmail.com, and I am Jennifer at nvpoa.org. Thanks, and hope you have a great day.